Good morning, everybody. Thank you very much for joining us our panel entitled "In Pursuit of Justice: Strengthening International and Ukrainian Legal Infrastructure" with our prominent experts. Russia's aggression against Ukraine and the mass-scale human rights violations committed by Russian forces have caused a strong international response and also started a complex of accountability efforts undertaken by Ukrainian authorities and international community. 2 days after the invasion, on February 26th, Ukraine has filed a case against Russia before the International Court of Justice concerning allegations of genocide under the Genocide Convention. Only a few days later, the chief prosecutor of International Criminal Court, Mr. Karim Khan, has opened investigation into past and present allegations of war crimes, crimes against humanity, or genocide committed during the war in Ukraine. At the same time, prosecutor offices in different European countries have launched their preliminary investigations into crimes committed in Ukraine. In March 2022, Lithuania, Poland and Ukraine have established a joint investigation team within the Eurojust network to investigate the alleged core international crimes committed in Ukraine. The Ukrainian authorities, human rights and non-governmental organizations have documented crimes, war crimes and human rights violations committed after Russian invasion from the very beginning of the conflict. So within the last 1.5 years, we have seen extension and development of different international mechanisms, expert bodies created to support or involved in support of Ukraine's quest for accountability and strengthen the national and international legal framework and operational capacities. The question we are going to discuss today, the challenging question, is how to harmonize all these efforts, how to provide effective justice for perpetrators of war-related crimes, and most of all, the compensation for justice for victims of these atrocities. These issues will be discussed during today's panels with our experts. Let me introduce Nadia Volkova, who is joining us online today. Nadia is a lawyer specializing in the human rights law, international criminal law, and she is director of the Ukrainian Legal Advisory Group. Veronika Kreidenkova, on my left side, is an advocacy manager of the Euro Foundation in Ukraine, promoting the rule of law and reforms in the sphere of justice in Ukraine. Iryna Kopanytsia is a woman rights advocate and both the CEO and advisory board member of White Ribbon Ukraine, an international campaign combating the domestic violence. Mr. David Schlaefer is the principal director of Ukraine in the US State Department's Office for Global Criminal Justice and the incoming senior assistance coordinator at the US Embassy in Kiev. Our last speaker is Timur Bondaryev, lawyer and founder and managing partner at the Arsinger Law Practice Firm in Ukraine. Thank you very much to all panelists for appearing today, joining the panel. Now I would like you to shortly introduce your institutions, organizations, and work in the field of accountability and related spheres.
I will take the call first. So my name is Veronika Kreidenkova, and as my colleague introduced me, I am the advocacy manager of the NGO, the Euro Foundation. It's a think and act tank in Ukraine that succeed in relaunching the judiciary governance bodies, the key judicial governance bodies, and implemented the competition procedure to the Constitutional Court of Ukraine. But my key role as for now is the coordinator of the Public Integrity Council. It's half civil society, half public authorities that the commission of which is to take integrity checks on judges within the process of qualification assessment. It's a special vetting procedure of Ukrainian judiciary, within Ukrainian judiciary, and our upcoming challenge is to vet the amount of 2,000 judges within Ukrainian judiciary, in other words, half of the Ukrainian judiciary, and to assist the competition to the position of judges for the appellate courts and the Supreme Court of Ukraine.
Timur?
Yeah, thank you very much again for having me here. I'm a professional lawyer, and I think that I'm the only one here who is speaking mostly about the business issues, right? Because we have plenty of experts who will focus on their speech on the human rights issues, which are extremely important. But we also have to understand that there are businesses who have been suffering billions of damages, businesses who have been paying taxes and who will have to pay taxes, and who will also have to have sort of vision how they will be compensated. And my report, my input today will be focused actually on the ways how businesses can get compensated, what are the avenues, what are the pitfalls, and what we should seriously think while thinking of the future justice system after all.
Hi, my name is Iryna Kopanytsia. It can be strange why I'm here if we focus just on like small sphere of prevention of domestic violence and fighting domestic violence, but war became a challenge for all people or all organizations, and we face so many issues that I never faced before the war, and of course we had to change focus from one into hundreds or dozens other focuses. So we faced issues and were applying cases on human trafficking in Europol, including in some countries like in Poland and Portugal and Ukraine. We faced issues of sex trafficking, kidnapping, some pedophilia issues, so like war attract all these kind of people. And working a lot with women and with children is related to women. So all these kidnapping issues as important part of war crime evidences in applications to ICC became an important part of our job. So, and I will focus on that later.
Thank you. And I'd like to thank the organizers of the panel and of the event. It's a real pleasure and privilege for me to be back in Jessup again. And again, my name is David Schlaefer. I am here representing Ambassador Beth Van Schok, who is the Special Envoy, the Special Ambassador of the U.S. Department of State for War Crimes and Accountability. I've been working with her on a detail for about the past 7 or 8 months. And of course, as I'll talk about in a little more detail in my presentation, this is a huge priority area for the United States of America, working both with partners in the international community, in international and multilateral legal fora, but also working with the government of Ukraine, inside Ukraine, with the Office of the Prosecutor General, with the Ukrainian government and authorities writ large in helping to build capacity in Ukraine for justice and accountability issues. However, I will note briefly, before I did this detail in the Office of Global Criminal Justice, I was actually at our U.S. Embassy in Kyiv. I was there during the crisis. I was there during the invasion. I was the assistance coordinator. I was part of the group that came here to Jessup and lived here for about 4 or 5 months. Was at this airport just about every day, in February, in March, in April, dealing with assistance issues in those chaotic early days, basically just trying to find ways to facilitate and normalize the flow of assistance into Ukraine. And I had the privilege of when our U.S. Ambassador Brink, arrived, and we reopened our embassy to go back in with her and to be her deputy for several months in the early days of the reestablishment of embassy operations. So I am on my way through back to Embassy Kyiv for another assignment focused upon assistance. And again, very pleased to be here and have an opportunity to talk about accountability today.
Yes. Can you hear me? Because I can't see anybody, so hopefully you can see me and you can hear me. So as Dominika mentioned, I'm a director of Ukrainian Legal Advisory Group, and this is an organization which has been focusing on the sort of justice-related issues stemming from the armed conflict in Ukraine since 2014. The organization is not that old. We were founded in 2018, but the core team had been working on these issues pretty much from the start. The main focus prior to invasion was on Donbas, the violations that were occurring during the armed conflict in eastern Ukraine. Less so on Crimea, because in Ukraine we have a very wide range of organizations working on Crimea, and at the time Donbas situation was suffering from the lack of attention. So we were mainly focused on representing the victims and survivors of eastern Ukraine conflict. We were representing them domestically and in regional judicial institutions such as the European Court of Human Rights, and also later on when the ICC, Ukraine recognized the ICC jurisdiction, we started cooperating with the ICC. Obviously, when the invasion started, we sort of had to scale up. Our activities didn't change all that much, but in terms of scaling up and extrapolating whatever the experience we'd already gained, that was pretty much what we had to do after the February 2022 events. I'm happy to be part of the panel and looking forward to our today's discussion. Thank you.
Thank you very much. Nadia, maybe addressing the issues we just mentioned. As we all know, most of the Ukrainian official but also unofficial infrastructures, NGOs, human rights organizations have started their work and on the question of accountability before February 2022. These documenting efforts, victim supports, is ongoing since 2014. Your organization, and I'm sure of our colleagues to have big experience in that field. Basing on this experience, how would you assess and the focus of your work, the judicial assistance? How would you assess the readiness of Ukrainian judicial system, the infrastructure, legal infrastructure in Ukraine to handle the prosecutions of war criminals, of perpetrators of international crimes? I would like to contextualize it in the context of these huge numbers of cases being already reported, and thousands we can expect to be investigated in the future. The requirements of the fair trials for war criminals, but also the need to harmonize the norms of international law with the provisions of Ukrainian penal codes, and of course the circumstances of ongoing conflict. How do you assess the capacity of Ukrainian judicial system to investigate the Russian crimes at the moment, and maybe also referring to the situation before the invasion?
Thank you for this question, Dominika. I will start with the obvious. It's a huge challenge. It had always been a huge challenge, and since the invasion it only became worse. I mean, I don't mean to not to sound not appreciative of all the international assistance that has been flowing in, especially because I'm someone who is in a position to compare what it was like before the invasion in terms of the assistance and attention that Ukraine was getting and post-invasion, and there's a huge drastic difference, of course. When we started working on Eastern Ukraine armed conflict, we literally struggled to get anyone's attention, because especially with the number of armed conflicts that have been going on around the world. I mean, I actually checked the statistics yesterday. I think currently there's over 110 armed conflicts of different scale happening around the world as we speak. While Ukraine, of course, is one of them, it's also one of the probably biggest armed conflicts in the past, I don't know, since World War II. And I guess the main challenge that Ukraine's situation sort of revealed, not just for, of course, the capacity of domestic system is not good enough to tackle, this huge number of violations that are occurring every day for the past, 9 years now? But obviously, it's a challenge that has been revealed in terms of the scale of the world, the international justice. Because if we look at the international justice as a sort of the mechanism that becomes activated once the sort of domestic system does not have sufficient level of capacity to process any of this, we can see on the example of Ukraine that the international justice system is not being efficient and effective. We need to obviously think about the new architecture, how we change it. In terms of, I definitely see that Ukraine is being catalyst in that regard. For example, you already mentioned the issue of documentation. While prior to invasion, the documentation practices were mostly sort of based around, field missions, NGOs going out into the conflict zones, or as close as they could get, or gray zone, and documenting, or, sort of documenting information from the people who would come back from the war zone or armed conflict zone for the purposes, I don't know, proceedings, or just to take it down, and archive it somewhere in the folder on Google Disk, or, that was the extent of it. Now, after the post-invasion, I mean, huge body of sort of evidence that is going to go into the court is going to be based on open source information. And we can already see that dynamic, sort of rolling so actively. You have now different archives. There are talks of establishing centralized archives, documenting open source information in accordance with certain standards like Berkeley Protocol. And then you see also different verification practices, how to establish that this evidence is actually, or information can, in the future, be admissible and be admitted in the court as, in the court of law as actual evidence. We also sort of, but while all these things are happening, parallel to that, we can see that domestically, for example, our system is too slow and too inert for the time being in catching up with these practices. Because, for example, our criminal procedure code does not recognize as such open source evidence, and therefore it's not forbidden by the courts. Like, it's not like, if an investigator or a prosecutor brings it to a judge, the judge does not necessarily just refuses to admit it or accept it, but it's discretion. And again, it falls back to the situation where a judge either he knows how to handle this information or he doesn't. And in the majority of cases, because the majority of judges who are saddled up with considering these cases now, they don't really have the experience or necessary experience. So that means that we end up in a situation where judges prefer to stick to what they know and how they deal with cases, or they're used to dealing with cases. And the war crimes related cases, they are not used to dealing with. You have literally several courts across the country which sort of have judges who have seen these kinds of cases. They have developed some kind of judicial practice. But again, it's still not up to par, required by the international law, international standards, and that very much affects the the quality of this work. Same goes for investigators and prosecutors. We have a situation whereby there is no, by law, National Police of Ukraine does not have the jurisdiction to investigate war crimes. Basically, all these articles 437, 438, 442, and so on, in that part of criminal code. So that means that they have to come up with different schemes how to go around it. In the meantime, there's a lot of time is wasted, and also evidence can be lost in that time, and they're quite detrimental to running of a smooth process, considering that these are the hardest cases to investigate. So it's difficult. I can talk about it for days on end, and I'm conscious of the time. If there are any specific questions, I'm happy to answer. But yeah, I will stop here for the moment. Thank you.
So, very short follow-up question concerning the normative aspect or level of these developments you just described. There were a few amendments to the Ukrainian criminal code that were supposed to enable the prosecution of international crimes. You have just defined some gaps or fields for improvement. Could you shortly describe this new legislation designed to support, enable, and enhance justice in these cases?
I mean, there have been quite a few. Most of them concern procedure or the process. So the latest one, for example, which we're all incredibly happy about and very much relieved, because we had been begging our authorities for a number of years to actually change the law in that regard. And so basically we had this amendment in our criminal procedure code which said that any investigation can only last for 12 months with the with allowance for extension for another 6 months. So the total 18 months for any given investigation, including the war crimes investigations. Actually, we at one point we arrived at this situation on the 24th of August. That was the last day when they actually the Parliament and had a chance to vote in the amendment and to actually for the president to sign it. Because the 18 months since the 24th of February were expiring on the 24th of August, and they actually the vote took place on the 24th of August, and they cancelled that. They sort of repealed that amendment in the case of war crimes articles. So basically we're good to go now. That's just one of the examples. There are also some of the weird amendments. We had an article on collaboration added to treason, and then, for example, in the sort of a law on cooperation with the ICC, that was a new sort of part added to the criminal procedure code. But again, there are quite a few sort of questions still pending, and whatever they adopted at the time, and it's still sort of it doesn't correspond to the standards that need to be in place.
Thank you very much. The question of capacity of justice system is not only the question of legal norms and their and the application of international law into domestic legal system, but also the practical aspects, the capacity of the judiciary. Veronika, could you describe this problem from your perspective of the capacity of Ukrainian judges, judicial system in handling all these crimes, and whether this terms of 12 months just indicated is realistic to handle war crimes prosecutions?
Thank you, Dominika. That's a great topic. So, for understanding the capacity, the operational capacity of the Ukrainian judiciary, I should start from the beginning of the full-scale invasion. And the Ukrainian judicial system faced with the full-scale invasion being in the setting as follows. First of all, absence of key judicial governance bodies. The HQCJ, it's the recruiting agency of the Ukrainian judiciary, was disempowered since 1919, so it remains unoperational at all. The High Council of Justice, the HR department of the judiciary, the most members of the High Council of Justice have been resigned 2 days before the full-scale invasion. That was the sign for us that something is coming, actually. It was a great surprise. But the key operational body of the judiciary remains disempowered also. The second thing, absence of judges. On the day of the beginning of full-scale invasion, there have been around 2,000 vacancies within the judiciary, which was half of the Ukrainian judiciary, actually. And the third thing is the lack of system of reviewing war crimes. As you know, the actual invasion of Russia to the Ukraine started in 2014, but Ukrainian courts used to consider such cases like the terrorism cases and participation in terroristic organization. That was the ground that for unprofessionalism of Ukrainian justices, because they have no experience with facing with such crimes, such complicated crimes, including international aspect of perpetrators from other countries. So, at the beginning of full-scale invasion, the state and the NGOs faced with the challenge to produce some efficient system to consider such crimes. Because as for now, we have 100,000 cases under the investigation. Maybe Nadia will make some introduction to this. And we have 5,000 cases that are already passed to the court for the trial. We, as professional NGO within the system, started to develop such a model, and we considered 3 main models. And the first model was about maybe we should introduce some international justices to the Ukrainian National Court. It means that foreigners could become a judge in Ukraine and join the specific cases regarding war crimes. But this model is expected to be failed because it needs the Ukrainian constitution to be amended, but it is prohibited under the martial law. So the second model we have considered was on establishing the specialized court of trying war crimes. We have succeeded in establishing some special courts, especially in the field of anti-corruption, because anti-corruption has a separate vertical in Ukraine, starting from the preventing body to the law enforcement body and the high anti-corruption court, which acts like the first instance court and both the appeal court. So the model seems to be worked out, but the war crime cases has such specific aspects. It reminds that you could have many witnesses and many victims distributed around the country, and specialization of the court, specialized court, will have only the possibility to be in the Kyiv. So it will negatively affect the timely manner of court consideration in such a case. So we skip this model also. So the third model was, which is expected to be most efficient, is to provide a separate specialization for the judges within the existing courts. The first instance courts, the appeal courts, and the Supreme Courts as well. We faced with the problem that there are some judges that have narrow experience in trying such a crime, but they are distributed around the country, and other judges have not such experience. So we are facing with a situation where some courts trying to deal with that, providing the separate specialization based on a voting process within the court. But the voting process is not based on the merits of a separate judge, because it's about only voting, not about the specialization, specific requirements you have, specific achievements in studying in the National School of Justice or somewhere abroad, and so on and so on. So the thing is that our legislation should be amended on this matter and provide special requirements on judges' specialization, including maybe previous experience or additional trainings, workshops, and so on, maybe somewhere abroad, Ukraine, because of the narrow expertise. And despite the workload and the operational capacity of the judiciary, the one point is always missing, and it hurts me the most. It is crucial for Ukrainian justice to have the judges of high integrity to consider such cases. The question is, did you believe in the court decision which is approved, which is by the judge who secretly obtained the Russian Federation citizenship? I suppose no. We also suppose that such judges could not be impartial in this case and could not maintain the truth-telling process for the victims of the war crimes. So it is crucial for us to have integrity checks for the new judges to join the system. As I mentioned earlier, we are expecting to conduct competition for 2,000 judicial positions within the next 3-4 years. So it is crucial to have the deep integrity checks on each candidate, because they will, their decision will affect the system and the perception of Ukrainian judicial system at all, and the most significant thing that it will affect the victims of war crimes. And the last point I want to emphasize that Ukraine is good when our international partners are helping by demanding. Ukraine always succeeds when we have strict rules to obtain some help. It was done in the system of anti-corruption cases and anti-corruption infrastructure, where international partners had the strict demands on everybody, every aspect of the system. And the Venice Commission calls it like the transitional democracy, the country of transitional democracy. We call it like kick-ass democracy within the NGO sector, but it actually works. When the international partners have strict rules to follow, it creates the NGOs the leverage to force the Ukrainian authority to follow the rules.
Helping by demanding, it's very interesting motto, like for introducing all these necessary reforms. And from what we know, a lot of this help by demanding or providing legal assistance, trainings for judges has already been delivered. Maybe the question to Nadia and Veronika on your views on these trainings and demands to comply with the standards of impartiality of judges, fair trial and rule of law. We will come to this question later, but speaking of international support and assistance, I would like to ask David Schlaefer if you could shortly address the US and international support for accountability efforts also in that respect.
That's a great question. I will jump in briefly. There was some initiative of training Ukrainian justice, but it's not a system as for now. It's initiatives of separate donors and organizations.
We will come back to this question, David.
Great, thank you. So I think what I'd like to do in my short presentation is really to talk a little bit about US efforts toward accountability. I'm going to start off talking about US assistance and partnership in the international sphere with multilateral organizations, with other international partners, but then I want to focus upon what the United States is doing on the ground in Ukraine in order to help capacitate the Ukrainian government. But before I do any of that, I'm going to start with a quote. And I think that this quote, it's very simple, but I think it's very profound, and I believe that it sums up very succinctly the philosophical, the moral, the legal, the ethical, the policy-based perspective that is behind US support for accountability in Ukraine right now. And it's a quote from Secretary Blinken. It's something that he said at the United Nations just a couple of days or a couple of weeks ago, I guess I should say, when he was addressing accountability in Ukraine and American interest in that. And this is a direct quote from Secretary of State Blinken. Bucha is not normal. Mariupol is not normal. Irpin is not normal. Bombing schools and hospitals and apartment buildings to rubble is not normal. Stealing Ukrainian children from their families and giving them to people in Russia is not normal. And we, the international community gathered here today, must never allow these crimes to be normalized or committed with impunity. And I think what the Secretary was getting at there was two things. Number one, the concern for justice and accountability inside Ukraine, and then along with that, attendant upon that, let's say, his view and the view of the United States that what happens in Ukraine with justice, with accountability issues in this conflict will have ramifications for justice and accountability throughout the entire world, throughout the entire globe. It is an inflection point, let's say, and for good or for ill, the way that the international community is able to support and help and manage the issues with Ukraine is going to have very significant global ramifications. So going ahead and pivoting then to the first part of my presentation, U.S. approach to the war of aggression, Russia's war of aggression writ large. There are really three pillars that we talk about in the U.S. The first of these is, of course, strengthening Ukraine on the battlefield. The second pillar is alleviating humanitarian issues, humanitarian suffering of the Ukrainian people. And number three, supporting in multiple pathways justice and accountability, which is what we're talking about on this panel today, and which is what you are interested in. And it's this third pillar that I have been working with the U.S. Ambassador again for Global Justice, Beth Van Scott. And she was appointed by Secretary Blinken very shortly after the conflict began, and he asked her to really lead U.S. efforts in partnering with like-minded countries to do what he talked about in that quote that I gave you, to show that these horrors that are being committed on a daily basis cannot be tolerated, will not be tolerated, and they cannot be committed ever with impunity. So very briefly, I'm going to cite some of the chief U.S. accountability initiatives that we have launched outside of Ukraine, in the international community, in the multilateral community, or that we are participating in. This is by no means an exhaustive list, but a short list, I think, of some of the key efforts. And I know that some of you, a handful that I actually know or recognize in the audience, are involved with these in some way. The first that I'll mention, and we may talk a little bit more of this when we're talking about child deportations in a bit, is the Yale Conflict Observatory. And this is an independent program that is using commercially available technology, geospatial data, and tracking systems to monitor, to track crimes and atrocities committed by Russian forces or by Russian proxies, and which has become instrumental in the documentation of filtration efforts, deportation efforts in particular, child deportations, and crimes committed in the, let's say, the destruction, the sacking of cities like Mariupol and Bakhmut. Second initiative I'll mention is the U.S. Commission on Inquiry, and its very broad mandate, of course, to investigate all alleged violations of human rights. Related to that, U.S. support for the UN Human Rights Monitoring Mechanism was already active in Ukraine prior to the conflict and remains active. The OSCE's Moscow mechanism and the multilateral diplomatic engagement that the OSCE is involved in multiple areas related to war crimes accountability. We've already had mention of the Joint Investigative Team and the JIT. And then finally, these so-called, I usually refer to them as emerging international institutions, accountability architecture and justice architecture that is specific to Ukraine and it is being built and fleshed out even right now. Among those would be the International Center for the Prosecution of the Crime of Aggression, the claims registry that I think that's Council of Europe initiated in Strasbourg, that the United States is right now literally this week in the process of formalizing, I believe, our initial grant or our initial award to stand that mechanism up. And then going forward in the future, potentially, the special tribunal for the crime of aggression. Now, for the second half of my presentation, I'm going to focus specifically then on what the United States is doing inside Ukraine. And chiefly, what we were doing is supporting Ukrainian capacity through the Atrocity Crimes Advisory Group, the ACA. This is an umbrella that is designed, again, to help capacitate Ukraine's ability to provide justice for victims. The United States has contributed $25 million to this initiative to stand it up so far, and very likely that there will be additional funding, and it is, of course, a multinational initiative. We do this in conjunction with the EU and with our partners in London, with the UK, in order to pool collectively the resources of the three countries, or the three groups. There are various implementing organizations. They're all working on the ground in Kyiv and elsewhere right now in Ukraine, in fields such as international humanitarian law, international criminal law writ large, a very heavy focus on conflict-related sexual violence, increasing focus upon issues involving crimes against children, victim and witness protection. And the knowledge and the expertise of the individuals who are being seconded and detailed to work through the ACA umbrella on these issues is experience born from their work and their commitment to conflicts in other regions, in Cambodia, in Rwanda, in the former Yugoslavia, in Sierra Leone. And I think that it is important and significant and poignant to think about the fact that someday we're going to be referring to Ukrainians and people who are working inside Ukraine right now in this field and in these capacities as probably having the most experience of anyone anywhere in the world, and they'll be working elsewhere. They will be called upon as the subject matter experts for ACA-type initiatives in other places, given the scope and scale of the issue inside Ukraine. The United States is absolutely committed to continue to support the ACA on the ground in Ukraine and help Ukraine in this overwhelming task, right, that we've already talked about, the sheer number of cases and investigations involved. I saw something from, maybe it was the Prosecutor General Kostin the other day talking about more than 100,000 recorded war crimes. I think I heard that figure, 100,000. The ACA investigators are involved with every aspect of investigating and prosecuting war crimes in Ukraine, from mobile field teams that are working in the field where the atrocities occurred, engaged in evidence collection, in forensics, and then taking that evidence and taking that information and actually building cases, building dossiers, and then prosecuting those cases in what I believe is now more than 100 successful or near 100 successful prosecutions in Ukraine for war crimes. The ACA has played a role in almost every one of those in some way, in some form or fashion. So it is effective. It is achieving results on a daily basis. I think let there be no doubt that while much of the ACA's work happens behind the scenes, it's not as visible in international reporting and press reporting and media. You don't read that much about it in the open press. It is working closely daily with Ukrainian colleagues to manage these challenges of documenting evidence and dealing with these very complex legal issues. We're very encouraged by this, and we think that the world, again, will really look to the expertise of ACA and the trails that it is blazing in the future, both in Ukraine and beyond Ukraine elsewhere. And from the United States perspective, our commitment to justice for Ukrainian victims and survivors in Ukraine, here in Poland, and elsewhere around the world now, is absolutely solid. You are not forgotten, and we will continue to work with you and for you, with others around the world to support you. Thanks.
As you mentioned, the Atrocity Crimes Advisory Group is a very effective framework involving European and partners from European Union, US and UK. Are there any plans to open up this initiative to other partners to extend this network or framework of support?
Yeah, that's a great question, and I'm glad you asked that. And the short answer is yes. We are looking at different models of multinational funds right now that might be applied to the ACA. Models such as the Multinational Fund for the Global Coalition to Defeat ISIS, right? The Defeat ISIS coalition that was put together with European partners, African partners, Latin American partners in the United States several years ago, something along those lines that would allow, beyond the three partners that are the founding partners, other interested countries and nations to align their efforts in some way and to provide support, probably through some type of multinational fund, and expand this. And we think, in addition to the benefits of policy alignment, this will also provide a greater measure of long-term sustainability for the ACA as it continues to evolve, and we are very much committed to that long-term sustainability of the organization.
Long-term sustainability and perspective or outcomes of the processes we are discussing now is another interesting and important aspect. I hope we will come back to this in the second round of questions. Now I would like to move to my question to Ira, which also refers to issues already discussed, the problem of forced deportations, kidnapping of children, that gained big international support, public attention, and finally also recognition by the ICC with the arrest warrant issued in March 2023. If you could give us a closer look and some insight into documenting these aspects of Russian crimes committed in Ukraine, victims' perspective, and also this application process you have already mentioned at the beginning, the ICC application.
I won't, thank you. I won't mention the same fact that you already probably heard or seen a lot of times, or the same numbers, like how many children. I'm pretty sure that everyone know how many children were deported. I'm sure that those numbers, like everyone want to have with evidence, proof, databases. Everyone know that it's we have a data of like 19,500 children. But again, talking from the side of my organization, my opinion that on the period of the first half year of the war, there already was a confirmed number of 300,000 children. So this is of course unofficially, because we never can get any proofs or evidences for that, but this is basing on our cooperation with NGOs working on frontline a lot, of sometimes some Russian NGOs that were willing to cooperate and help, but it was like, you know, a few months of cooperation, they could disappear, but even from their side it was confirmed numbers by the August of last year. As well as a lot of information you can find in open sources. I mean, on the background you can see just some slides of presentation we made. I won't mention in detail on each slide, but there is just a huge data of all different open sources investigations. Of journalists, of some NGOs, of some from Russian sources, Russian media. So most information you can find in open sources, actually, as well as in some reports, like diplomatic reports that Russia sent itself. They actually say a lot of numbers. Yes, they present them from other angle as how many children or people were saved. Yeah, but we know what is the real picture, and they have reports that they've been sending for diplomatic authorities. So, talking about open sources, there is important for us to study it more detailed and to find out how we can use this information, like maximum effective. Because you can find everywhere, like 3,000 children were deported to Belarus, like over 7,000 in Crimea campings of I forgot the word, okay, for educational or militarization campings. But it's all details. We are in a strange situation when the whole civilized society have to prove, dealing with criminals and terrorists, to prove that. Like, they don't follow any law, any agreements, and we have to prove and to find evidences and to find these proofs, following the law, being quite tolerant and being quite diplomatic. So my idea is that definitely something needs to be changed on the level of procedures and some protocols of international organizations and international policies, because to find these proofs and evidences, we have to be in gray zone actually. We have to do a lot of things unofficially, as well as talking about rescuing operations. We know pretty well that rescuing children and people from Russian side, it's not a secret that is most part of the process is an official process. So it's kind of fighting with criminals. We have to become criminals ourselves, or how? So something needs to be changed from legal side. And I believe in superpower of NGOs and grassroots organizations. I am pretty sure that joining efforts between us, between them, we have much more. We have sometimes much more success than sometimes on government level. At least what I see from the beginning of the war. But we need better coordination. We need to build some more coordination center, I don't know, whatever, yeah? Like from the beginning of the war, we've been working closely with Save Ukraine, with Nikolai Kuleba. And we've been cooperating for maybe last 6 or 7 years, starting with the changing law on mentorship in orphans' houses and scaling it geographically all over Ukraine. But we didn't have time to catch up personally. That was all in telephone with his team. And then finally, like just a few months ago, we had a personal meeting and we found out that there were so many topics, like non-telephone topics, that if we could meet earlier and exchange information and networking and some insights, we could be double or 3 times more effective a year ago already, or a year and a half ago, or on the beginning of the war. So we definitely need some international coordination center or something like this, because coordination process is a huge trouble, and in the government level, in between authorities, and in between NGOs, which are separately very effective. They do amazing job, and the Crimea Human Rights Platform, NGO organizations, they're doing amazing job. Talking about rescuing operations and bringing back children that were successfully brought, it's like over 380, I guess now it's even more. It's supposed to be plus 12 or something like this. I mean, not most of them, all of them were brought back by Nikolai Kuleba, by Save Ukraine. And each case is like a special operation. It's really like half military operation. And joining efforts of the whole world, of other governments, other NGOs, and changing some procedures from legal side, that could help us a lot. The other thing that I would like to mention, that talking about awareness campaigns on kidnapping children, yeah. I have no answer, but I have more like a question. Are we sure that it's a good instrument that push Russians and that help us to prevent like next cases of kidnapping? Because that could be the other side, like they ignoring any law, yeah, they ignoring any pushes. So that could cause even more active kidnapping and some human trafficking issues, maybe like for gathering exchange fund or something like this, like what they do with prisoners, yeah, military prisoners. So this is like a question for no answer. Like we need to see each problem from both sides. How can it help, or how? And again, talking about this more and more, but still staying a bit in gray zone with these rescue operations. We give information like to our enemy. So we need to be accurate with that, with this side as well. Like recently giving some interview for some American actually media, but there was a Russian journalist. Yes, she left Russia 10 years ago or 15, but still she was trying all 20 minutes. She was trying to repeat the same question, like how exactly you get back the children? No, what is the procedure? How physically the process is going on? And of course, not even one time I was answering these questions, because first of all, there are some unofficial processes, and second, we cannot give them information because for now we don't have fully official procedures of bringing back. Talking about official exchanging process, so on our last meeting, Nikolai mentioned that actually those cases that were when there were attempts to make like exchange process and negotiations with Russian side and with their how to call the authorities, but it's not definitely ombudsman and not human rights, but okay, with their officials, yeah. And all those cases were the most complicated finally. And for now, of up to 700,000 children, and I'm pretty sure that numbers like this or even more, as for last August it was already 300,000 children, so guess even much more. And most of them, they don't have parents, or they don't have relatives, or it's not possible to have to make a DNA test or whatever. So it's like we are in a zone when we have no chances, seems like for now, no chances to prove this, to find evidence. It's the same like, okay, we can apply and ask for I don't know, Vatican or for some world organizations to help, but they all ask, okay, give us proofs, give us data. But data and proofs, it's actually, we need help with that. It's exactly what we need help with. So this is like not becoming a criminals in making rescuing operations. This is a very big challenge and a very important part of the story. And also wanted to mention that we need better coordination from the side of International Criminal Court, because, for example, applications for Maria Belova and Putin, when they were recognized as criminals, and when we were talking, again on the same meeting together with Nikolai, we were talking with the team who personally was making and writing these documents for those applications. And they were collecting all those proofs and and following all the procedures, what parameters should be included while in those applications, with the help of people responsible for the same applications in Yugoslavia, actually. So it was not like from, as you mentioned, yeah, they help a lot. So it was not like ICC gave the whole structure and our Ukrainian team easily could prepare everything. No, our team was inviting the Yugoslavian team. They were consulting a lot with support with some American organizations and NGOs and government organizations. And all together, it took 1 year. So if ICC was more open in coordination and cooperation, that would help a lot as well. As well as we all know that there's quite a strong influence of Russians to different authorities all over the world. And they still have some influence on some workers in ICC. So this is like another issue that also need to be mentioned, and we also need to investigate this and help them with themselves a bit.
Thank you very much for these remarks. The follow-up questions concerning the need for coordination and the better or more direct communication with the ICC, I hope we will have time to address in the second round on these concluding remarks of our panel. I would like to move to the last question and our last panelist, also referring to the wartime losses, sufferings, but this time not of individuals, but of Ukrainian economy, businesses, legal persons. As David Schlaefer already mentioned, the Council of Europe has agreed to create a register of damage for crimes and to compensate victims of Russian crimes in Ukraine and to develop international comprehensive compensation mechanism for the victims of Russian aggression, although this mechanism, at least at the moment, focuses on individual victims, their sufferings and wartime losses. Timur, what is the answer, what are the solutions for businesses, for legal persons suffering in Ukraine from the Russian aggression?
Thank you very much, Dominika. Thank you very much for having me here today. So obviously it's another very important angle of this war. So we understand that every day, every hour, Ukrainian businesses are suffering huge losses. We are talking not only about direct losses, but also indirect losses, loss of capitalization, etc., etc. At the moment, there are hundreds of billions of dollars which were suffered by Ukrainian businesses, and nobody really knows how these damages will be compensated and what will be the horizon. As a matter of fact, there are actually very clear avenues at the moment which businesses can use to claim damages. I can break them down in two groups. One group is those which have been around for many years already, and others which are about to evolve. So these existing ones would be the European Court of Human Rights, national courts in Ukraine and outside of Ukraine, and investment arbitration. European Court of Human Rights, unfortunately, this opportunity is not available anymore because Russia was expelled from the Council of Europe, as you know, and respective claims were to be submitted until beginning of this year, somewhere 16th of January, if I'm not mistaken. There was a sunset clause. So those who have managed to submit the claims, they have done it actually. Those who knew, I mean, I cannot tell you that European Court of Human Rights is the most efficient tool for this, but it's, I think, the most affordable one, right? We know very well the Yugos case. In the same matter, the investment arbitration has awarded damages $50 billion, while European Court of Human Rights awarded just $2 billion, right? But anyway, it's a good avenue, and those who have taken advantage of it, we are waiting for the outcome. I think that on our firm we have submitted like several dozens of claims on behalf of our clients, but as I hear from the court, there are thousands of claims which have been processed, and the court is expected to come up with some, I don't know, flagship decision how they are going to handle them. Second big group are the courts, national courts, and then foreign courts. Ukrainian Supreme Court has made the decision that they are very happy to, so to say, embrace the claims against Russia. We, Ukrainian experts, we are very much skeptical about this, being honest with you, because from the angle of the international public law, there is a concept of sovereign immunity of the state, and unfortunately, even though we all knew that and know that Russia is a terrorist state and has breached all possible laws, habits of this world, still they're sovereign, and actually there is sovereign immunity, right? And the national court is not allowed to take the state to the national court. So it's a big problem. But anyway, Ukrainian Supreme Court has said, guys, no worries, go ahead. And we've seen a number of claims against Russia in Ukrainian courts, and we've seen a number of successful claims confirmed against Russia. Again, we don't recommend our clients to go there just because we don't think that it's a very feasible tool, but some lawyers have been advising their clients to do so, and these sort of claims they are filing. And in terms of affordability, it's actually quite affordable in comparison to investment arbitration where I'm heading to, which is, to me, as a practitioner, and I've been doing investment arbitration for many years already, we think that this is a nuclear bomb. This is the best what you can have in this sort of situation, given the efficiency, given the expertise, given the that you can enforce the award of investment arbitration court all over the world, since the majority of the civilized countries have joined the New York Convention, which allows the recognition and enforcement of international arbitral awards. The main problem is cost, right? Investment arbitration is very, very, very expensive. So we are talking about the millions of dollars of legal fees, of expert fees, arbitrator's fees, etc., administration fees. But again, it's really very, 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 very efficient. And we started seeing clients who are happy to embrace this opportunity to take Russia to investor arbitration. Good news is that we started seeing financial guys, litigation funders and private equity funders, players who are happy to finance the claims against Russia, since not everybody is really happy to throw good money after the bad money, right? And a lot of clients who have been suffering hundreds of millions of dollars damages, they just not happy and not sure if they want to take money they had to finance the claims against Russia. Bear in mind that the enforcement prospects are still very foggy. This is where I'm heading to. But again, what we've seen, most recent development is that we are now working on at least 2-3 claims where the funders, private equity people from US are seriously interested to finance these claims. First of all, they're focusing on the old claims, those from the 2014 DNR, LNR, and Crimea. They are not ready to finance the most recent claims because legally it's very difficult to establish the jurisdiction for investment arbitration court with regard to the damages, for instance, of the companies which were suffered around Kiev, right, during the temporary occupation. So there should be like political control, etc. So occupied territories, yes. Not occupied territories, no. And again, the damages should be really very, very, very significant because again, the legal costs, expert costs, we're talking about the millions of dollars, right? So this is it. Those which are evolving the compensation commission, right? I mean, it was mentioned already today. It's evolving. The general architecture of the compensation commission is actually quite clear. There will be the register, which is already created. There will be compensation commission actually, and there will be compensation fund, right? It takes time to create it. We don't really know when it will start working. Again, the register is there, which is great news. But there are a lot of question marks, right? Which we don't really know how to navigate our clients because we don't understand what will be the approach to compensate. The only thing which we understand now, based on our discussions with the government, is that unfortunately businesses will be treated not in a first round, so to say, right? Which is, on one hand, I understand is okay because the businesses, they can take care of themselves, but on the other hand, again, we always have to keep in mind that businesses, they have been paying taxes, they have been employing people, and they have to also think of, right, thought of. But again, our clients, major businesses who have been suffering huge losses, they actually don't really believe in the compensation commission because they don't really believe that there will be enough assets, enough money to compensate them, right? After the individuals have been compensated, after their personal staff was compensated, after the state was compensated. So therefore, claims commission is at the moment not really considered as the efficient tool by our corporate clients. Again, I'm talking about the guys who have been suffering billions of dollars. We have signed up the clients in the total amount of about $5-6 billion, and these claims are growing. So this is it. This is about the avenues, right? And the last point, which is very important, is the source of compensation, source of enforcement. I have mentioned already the topic of sovereign immunity. And this is the topic which have to be very, very, very carefully attended to, because we understand that following this war, the world will look very much different. We know this has always been the chance after the big wars. We remember that after the First World War, a legal nation was created. Why? To prevent further wars, right? It failed. After the Second World War, United Nations was created. Why? To prevent further wars, right? To create the national security system. Does it work? No comments, right? So therefore we understand that we will see the very new, very reshaped international security system, right? Which will have to attend not only the issues of the general security, but also the issues of the foundation stones of national public law have to be attended. Because again, we know that Russia is a criminal. We know that Russia is a terrorist. But they keep sitting on the Security Council and keep showing the finger to everybody, right? We know that they're terrorists, but we cannot touch their assets. Come on, how comes? But there is sovereign immunity, right? And so this is a very, very, very big topic. At the moment, based on the Uczkiewicz case again, Uczkiewicz case has been around for several years in a row, $50 billion claim, right? Award, enforcement award, they cannot collect it. Why? Sovereign immunity, the assets are very much hidden. Alter ego concept doesn't really work very well. So therefore, all these concepts, which have been around since Versailles Convention, which have been around for 75 years, they have to be addressed again. And I'm pretty sure that the international public law will look very, very much different. And it will allow to grab the assets of the state-owned companies. It will allow to grab the assets of the oligarchs who have been supporting the regime, etc. At the moment, we know that all over the world, the civilized nations, they have expressed their readiness to support Ukraine. A lot of assets have been frozen all over Ukraine, but not everybody is really happy to start using these assets as a compensation, right? US has done great first steps, actually, and I remember that the first assets and first money was already provided to the Ukrainian government, which is many thanks. But we know, and my discussions with the governments of other countries, people are still very much hesitant. They are not really sure whether they would be entitled to transfer the assets to Ukraine. Another angle, by the way, that they do not really trust in Ukraine, whether Ukraine will be disposing of these assets properly. So it's another angle which I wouldn't want to mention here. So therefore, to cut the long story short, we will see a huge reshift of the entire system. The avenues are there. It's possible to use them for businesses. But I think that the main challenge will be actually this classification of assets and just to change the legal system, to change the international public law in a way which will allow to make the land burning of everybody who has been supporting the regime or everybody who has been profiting of the regime. This is it. This is all from my side. Thank you.
Thank you very much for these very important remarks. The question of sovereignty, immunity is not only crucial for the public international law, public international criminal law, and is also bound by this rule and principle, which is widely discussed in the context of putting leaders of Russian government, Russian president on trial. which I hope we will have time to discuss in the context of the Special Tribunal for Aggression that has already been mentioned, or other initiatives to trial, to exercise the accountability, establish the individual criminal liability for the crime of aggression. But since we have only 10 minutes left, I would like also to give our public the chance to share with us your comments, questions, or remarks to all topics covered by this panel.
Thank you. Hello, I'm Olena Sladnik. I also want to ask your opinion, and can you explain your vision of Rome Statute of the International Criminal Court in Ukraine? What is the situation now with ratification and what can be done? Also, we've heard your part of your thoughts about OSCE and safety system in Europe. Can you give us your vision of how this situation can develop? Where are we going with this whole world, and which mechanism can be proposed to solve this problem, the safety problem in Europe? And also I want to ask about Black Sea and Danube shipping, which are possible mechanisms of compensation, the damage with sea and rivers and shipping can be proposed.
Are there any other questions at the moment? Nadia, would you like to answer?
Yes. In the interest of saving time and trying to kill one bird with two stones, I can actually tie the question of the ratification along with the Special Tribunal on the Crime of Aggression. So just to, from the outset, to make myself very clear, we do not support as an organization, and also we are members of Ukraine 5am Coalition, one of the largest coalition of Ukrainian NGOs, the idea of creating the Special Tribunal on the Crime of Aggression in the form that is being proposed and being discussed currently at the international and domestic level. I'll explain why. First of all, because the crime of aggression has already been codified in the Rome Statute. It's not perfect, but it's there. So why create another entity which is going to cost another millions, billions of dollars for prosecuting top leadership in absentia, and is not really clear to me. Also, what kind of justice can we expect to get in that tribunal for the victims, and who are the victims of the crime of aggression? This is also a big question for us. Am I a victim of a crime of aggression? Because I've never left Ukraine, and we've been experiencing, missile attacks almost every night. Or, I don't know, are my children victims of the crime of aggression, or that is too remote? So all these questions are very unclear, and I understand that there is a need to establish certain practice for prosecuting this crime, but again, too many questions involved about double standards, about the technicalities, and about the cost. We already have an institution tasked and mandated to prosecute this crime, but it's not working there. So I would rather work on a mechanism that would allow the ICC to actually prosecute this crime, rather than creating another entity which is not going to quite satisfy the needs for justice, at least here in Ukraine. That brings me to answering the question on ratification. So the latest on ratification, as you know, Ukraine has been adamantly postponing and refusing to ratify the Rome Statute, despite the fact that the ICC has the jurisdiction over the territory of Ukraine since 2015. First it was a preliminary examination stage. Now there's been a fully fledged investigation opened. Even the field office was opened last week, I believe, and also surrounded by mystery. Nobody knows where it is, what's supposed to be doing. But apparently it's there. There's been pictures of the prosecutor, Karim Khan, alongside prosecutor Kostin. So that must be true. We also heard that one of the latest démarches that the EU organized, EU delegation for the Office of the President, in response to that démarche, the Office of the President and the MFA said basically that it's not, we want to ratify the Rome Statute, we've wanted to ratify the Rome Statute, but there is a need for more outreach and also not just among the population but also the military. Now our response to that is that basically we've known about this excuse from Ukrainian government for a long number of years now. It's not original, it's not something new, and to that end we actually did a poll and we had focus groups. We did a study among the veterans and servicemen to gauge their attitude towards ratification, and actually we received an overwhelming positive response from them. Okay, granted, some of them didn't know what it entailed and what Rome Statute was in general, but actually there was no active opposition, and even in the majority of cases there was active support of ratification. So I assume when Office of the President talks about or speaks about the unwillingness of the military, it's only a handful of generals who don't, old school generals who don't understand what it is, and there's no one there actually to explain to them what that means. And also, I think there needs to be, I agree absolutely with Veronika that, Ukraine does better when they're actually responding to demands from the international community, and this is the situation. I mean, it's absurd. At the point of absurdity now that they're coming up with different excuses why they're not ratifying, considering the amount of resources and attention that's been put into Ukraine, invested into Ukraine, and it's just really it's not going to change anything anyway. The ICC has the jurisdiction, so the idea of not ratifying it is not even, it doesn't make any sense to anyone anymore from what I can tell. So we're there. And we actually have been asking the international community, especially the EU, to actually put more and more pressure on the Office of the President, because it's the decision of the Office of the President, no one else. Even though they're trying to say that it's MPs who have to vote, but we all know and understand that the majority and the single majority in the parliament is the presidential party, and they vote in favor of laws that they need to and they're interested in adopting. So I don't think it's such a huge problem, and we are happy to help them as much as we can with the outreach and other support that there is there. I'll stop here. Thanks.
Thank you very much, Nadia. David, would you like to address this question of accountability efforts in the context of the crime of aggression in recent statements by the already mentioned Ambassador Bedvan Shak, U.S. officials,
Sure. I mean, in the interest of time, we don't have a lot of time to go into it, which is good, because I'm not an international criminal law expert like my colleagues are in the Office of Criminal Justice. But there is a difference of opinion on this modalities issue pertaining to the special tribunal. And I think what I can say is that while no decisions have been made and discussions continue, I think that the U.S. position, along with our partners, has been fairly consistent in that we are focused upon what we refer to as an internationalized model that is based in the Ukrainian judicial structure with an international infrastructure layer of support as being the most practical and probably the most useful in the long term.
Thank you very much. We have 10 seconds left, so very short time for very last concluding remark. Ira, would you like to take the floor?
I would like to ask actually questions for my colleague. Maybe not waiting answering right now, but this is like will be open question. Okay. Is there some procedures or some mechanisms how we can punish propagandists and like middle-class propagandists, Russian propagandists, for calling for war? Like we have some initiative of volunteers that have been collecting data of these calls and these evidences. This is like from media or from their personal social networks, calls for the war, for genocide, for all other things. For now, in this data is over 12,700, not over, like 12,900 people. We have a mapping of them, like where they're located. We have some profiles and these evidences. Like I know that those successful cases for like Putin and Belova, yeah, and our Ukrainian team that was preparing and applying it. I remember that they told that they had to follow over 600 parameters. So that's why these cases were successful actually. Is there some more easy procedure, or this is like just useless data, or we can use it somehow effectively to punish middle-level regional governors and middle-level regional opinion leaders mainly in those data? So this can be actually an open question for the whole society, for our guests, for some international communities. Let's find out together a solution.
For today, this must remain an open question. Thank you very much for attending this panel. Thank you very much to our experts for their speeches and insight knowledge.